When victims are left waiting for years, justice is effectively denied to them. And this is a betrayal of our legal heritage, and it's a betrayal of the victims themselves.
The best opponent of the Justice Secretary's plans to curb jury trials is the Justice Secretary himself. In 2020, he said, "Criminal trials without juries are a bad idea. You don't fix the backlog with trials that are widely perceived as unfair."
That was the Justice Secretary, David Lammy, laying out his plans to scrap jury service for all but some of the most serious crimes in Britain. I'm Natasha Feroze. I am head of TV at The Spectator, and I'm delighted to be joined today by Simon Jenkins, author and journalist, and Andrew Tettenborn, who is a commentator and occasionally writes for The Spectator as well. Now, Simon, you were one of the few in the early stages, I think 4 years ago, to put your head above the parapet and say, let's scrap jury duty. I believe you called it a costly indulgence. So I presume you're happy with David Lammy's proposals today.
Well, I'm happy that he's going a very limited way towards what I think ought to be done. But I do think the entire debate has become completely archaic and pointless. We're talking about 2 to 3% of all trials in Britain. And they obtain an extraordinary amount of publicity as a result. But they are, I think they're deeply inefficient, they're very costly. I've been involved in 3 jury trials, and each of them was absurd, I thought. More to the point, these things are just out of date. We're the only country in Europe that still has juries. America has juries, and they're going out of fashion there. The system is collapsing in America, in fact. We really should get rid of them all. And I'm glad he's getting rid of most of them, or some of them, not most of them, some of them. The fact that it's also a crisis in the court system is a totally different matter. He clearly needs to try and do something to get rid of 80,000 cases, and I can understand the problem. And this is one way, a very limited way of solving that. But it's not the point. The point is that the jury trials, in fact, the whole sort of the tradition of the British trial, as if it was a sort of play acted out on a stage, is quite wrong. It sends far too many people to prison. We're obsessed with prison in this country. All of Europe has a better system, and all of Europe has fewer people in prisons.
I think I read somewhere that a jury is more likely to acquit someone who ordinarily with a judge would be sent to jail, particularly when it comes to political cases. So is it that the juries are sending more people to jail, or is it that they're more likely to acquit people?
Well, we don't know, because we don't know whether the acquittal was fair or not. We have absolutely no way of judging the jury system because it's so confidential. The ones I served on, in 3 cases, we didn't really do justice. We just honoured the rules of the court. But we send too many people to prison, period.
But that's nothing to do with juries, is it, Simon?
No, it is to do. My theory, for what it's worth, is that we dramatise justice in this way. We turn it into an act. Barristers and have to go at each other on the basis that there's one thing right and one thing wrong, which is very rarely the case in a proper trial. The way in which we do it is so different from how I've studied Germans and Norwegians and Swedes and French from doing it, which all I can say is that there's a better system, and one consequence of it being a better system is they send far fewer people to prison, and in prison, far fewer people reoffend.
Yeah, but that's nothing to do again with the lack of a jury or otherwise. The French do occasionally, I think, still have juries, and I think 1 or 2 European countries do. And there can be quite a lot of play acting in a French court. Now, I agree there is an argument for an inquisitorial system, but I don't think this has anything to do with juries.
Juries are sort of irrelevant now. I mean, in the first place, they are completely medieval. It's like saying we ought to go back to the system of having volunteer policemen and constables in local villages, or even hanging, drawing, and quartering for that matter. I mean, it's completely archaic. The fact that in the jury room you're not allowed to know whether the person who's been accused had any previous convictions at all for the same offence, because it'll distort their judgment, is, to me, quite extraordinary. And the fact that I was trying a fraud case, no one in the jury room knew what on earth was happening. It was utterly ridiculous. This is archaic. we've got to get to a system whereby evidence is tested and judged by reasonably scientific or trained people, and the judge, and I may say not just one judge, but a judge plus two assessors. I'm entirely in favour of that. Tries these cases. That's the way forward. That's the way forward, and we'll be there one day.
Oddly enough, I'm actually in agreement with Simon on quite a lot of this. So that will probably be very bad news for Simon. I certainly agree on the subject of fraud trials. A 6-month major fraud trial, if ever there's a stupid way to conduct it, it's through a jury, because you won't be able to have a representative jury, because you'll only be able to get onto the jury people who can stand 6 months out of their ordinary avocations of life, and they probably won't understand what's going on anyway. I'd also actually go along with Simon. I'm by no means convinced that, for example, you should have a right to a jury trial for stealing a Twix from Aldi, for a punch-up in Portsmouth town centre, or for damage to, or for something amounting to damage to property, or whatever. I think there are quite a lot of cases where actually David Lammy is right. And even though his reason is the thoroughly bad one that the government hasn't got any money, I think probably it's right that those cases should cease to be tried by jury. Where I'm not with you, Simon, is in the idea that juries should go entirely, and I'll explain later where I think they should stay. But I think there's more agreement than you might think.
Well, that's a great comfort, and thank you very much. I do think that there was, curiously, I used to be involved in libel trials. Libel trials no longer go to juries. There was a sense in which libel, rather like hate crime, needs the softening, if you like, of public opinion in the case to judge whether it really was a libel and so on. In those cases, I can see the point. In highly technical, for instance, murder trials, where an awful lot of injustice has been done down the years, I may say, by juries, I just want these things to be tested in the rigor of a rational discussion between the people involved, not in the wholly artificial context of a jury of a trial where two barristers, often they've only just been briefed recently by the solicitors, sort of perform in front of the jury, and the jury in effect mark their book as to whether they persuaded them in a dramatic case.
So, Andrew, do you think you could make the case for why it is very important to have a jury?
Well, I think it's selectively important to have a jury. Yeah. There was one point actually mentioned by Simon, which was the case of state trials. When you've got an offence where there is a danger of an overbearing state, and examples might be trials under the Official Secrets Act, trials of journalists for leaking documents, trials for misfeasance in public office. Now, in that case, there is an enormous temptation for any administration to weaponize the criminal law and use it against people it doesn't like or people who make themselves awkward. And I think in cases like that, it's actually very, very I think it's very healthy that the state should have to be able to get its case past 12 ordinary men and women. So that's one example. There are a couple of others as well, which I'll just go through. One is actually speech, which you mentioned earlier. When you're talking about cases involving free speech, and this is anything from insulting behavior likely to cause distress under the Public Order Act to actually speech likely to cause racial hatred, speech intended to cause religious hatred, and so on. These are very openly drafted laws. There's room for a great deal of disagreement between people as to what should be acceptable and what should not. And I think for cases like that, it's actually very important that they should continue as cases where there's a right to a trial by jury. I think it's very important that the government should have to be able to get trials for incitement to racial hatred passed to jury. There have been cases where people have been prosecuted very flimsily, largely, I suspect, to keep quiet a complainant, and a jury has very quickly thrown them out. That I regard as extremely healthy.
Can I come in just there and say I agree with both those cases? And if, as is the case in some jurisdictions on the continent, there are cases where you want to bring in a jury. They tend to be in precisely those sorts of cases where the matter is not the scientific dissection of evidence. It's in a sense a judgment as to what constitutes a crime. And I think where that's the case, and that does apply to both the cases you've mentioned, I do see that as the case whereby some higher court gives permission for a jury to meet to decide on the justice of the case. But
I think
actually, a tiny minority of cases.
It is a minority. I would go further, actually, and say there should be a right to a jury trial. And actually, this goes back historically a very long way. It goes back to Fox's Libel Act of 1792, which is a classic example of the state weaponizing the criminal law against those it didn't like. Because what the Tory government did, was frequently to prosecute people for criminal libel, and they got a complacent judiciary to hold, well, whether it's libel or not is a matter of law for the judge. So the jury is just told, well, did he publish it or not? And of course, he wouldn't be in court if he hadn't. And the point of Fox's Libel Act was exactly what you say, was to say that from now on, the jury gets the right to decide whether it's libel or not. Now, that's obviously past law, but I think it's a very good example indeed of why juries can actually be a good thing and why we need a right to jury trial in cases like that.
I'm not sure it's a right. But I mean, I'll give you another example. I was worried the other day by the people who were disrupting the M25 as a matter of political protest. And I thought sending them to prison was absolutely ridiculous. But leave that to one side. That's a sort of case, I think, where the state is, in a sense, as you say, weaponizing the law, and where it is reasonable to say, I would like to subject this case, although it's been passed by Parliament, this law, I would like to subject this case to 12 good people and true to see what they think about it. But this is not really what we're discussing. We're discussing thousands of cases, and there are cases which are clogging up the courts at the moment. I don't think clogging up the courts is a reason for injustice. I do think clogging up the courts is a reason for doing something about it. And at the moment, it's clearly absolutely chronic. Justice is not being done. And the fact that justice is not being done is a very good reason for trying to make it more efficient. I'm as much worried by the barristers, if I may dare say it in your presence.
I have never seriously practiced, so don't worry.
Okay, all right, that's a relief. But I mean, members of my family are lawyers, and certainly the business of for relatively minor offences, having a solicitor having to brief a barrister to appear for you before a judge, I think is completely archaic.
Solicitors have rights of audience now, or quite a lot do.
Quite a lot, but not all. Anyway.
Both of you agree there are some cases where there should be a jury. It's just the threshold at which there is one. Maybe you differ. Simon, what did you make of our editor Michael Gove's piece in The Times a few days ago, where he spoke about just the need for the public to have a sense of liberty, and for that to happen there needs to be justice to be seen to be done, and having a jury is a key part of that. And it reminds me actually of Parliament TV. When I watched the budget last week, a friend of mine said, what is the point of this theatrics, all this nonsense? And actually my response was, this is democracy in action. We need to be seen to be doing this so that people can see, so you can have robust debate, but also for the point of transparency. What did you make of Michael's argument there?
Well, I hesitate to disagree with an old colleague of mine. I always feel, if I dare I say it in your presence, I always feel that when you're trying to argue a case on what is, to my mind, a fairly important, detailed technical aspect of in this case, public law and order, and you have to refer back to Magna Carta, you've sort of lost the case.
Well, I think that's right. I'm with you, Simon, on that. It goes back to somebody who law professors keep on quoting Oliver Wendell Holmes, a very well-known American jurist, who has a very famous statement. It is revolting that there be no better reason for a law than that it was set down in the reign of Henry IV.
Excellent, excellent. A lot of things are in Magna Carta, which I'd love to revive, but I think we've got on beyond that. The most important thing now is justice being done? And I do have my doubts. An awful lot of people go to prison who shouldn't be in prison. And often the reason is the jury were not given enough information and they didn't have the expertise to correctly assess it. And that's a matter of technical procedure, which can be cured by doing away with juries and replacing them with experts. And I'm afraid in this case, I'm in favour of the experts.
Andrew, what would be your position on how rigorous the process should be by which juries are decided? For example, I'm up for jury duty in January, and I was thinking about who gets to decide who is in it. And I think it was back in 1974. All jurors were required to be taxpayers, property owners, or heads of households. And it was until the 1990s that there were far stricter rules about English proficiency. So let's say of the jury trials that are going to remain, do you think that there should be a higher quality or higher standard of the people that are in them?
I strongly suspect we need English proficiency. A higher quality, I think that ship has sailed, the idea of jurors having to be ratepayers. I think probably we do have to have a jury pool now taken out of the whole of society, provided that it reaches a minimum level of proficiency and indeed is a citizen. Possibly you might want a requirement that someone has been resident here for a certain number of years. It's actually quite important to have the right rules for who goes on the jury panel, because actually in the 1970s there was another rule of juries, which was that each side could remove without cause up to 7 jurors out of the panel. So the parties had a very considerable influence there. And actually, it was always said that the best way to avoid jury service was to rock up carrying a copy of the Financial Times and properly dressed. These days, it's actually much more difficult. Jurors can obviously be challenged for cause, but there are actually now no peremptory challenges, which means I think it is, as you say, quite rightly important that we get the panel right. I don't think we can start introducing financial or class qualifications to them.
Yes, it would be quite radical. I wanted to ask you both, maybe Simon first, the court system is in a serious crisis at the moment. There are nearly 80,000 court cases yet to be heard, and I think David Lammy said today that 11,000 cases were dropped because the victims simply couldn't bear to face how long it was going to take for their court case to be heard. This can't just be the only way to sort the court backlog. Is such a complex web of problems. Simon, what are the other things that can be done to try and fix this crisis?
Well, I'm not an expert in the administration of justice. I really am not. But in the first place, it is ridiculous how many things are criminal now. I mean, every year about another dozen crimes are listed. I think an awful lot of hate crime, an awful lot of crime to do with identity, a certain amount of fraud. Historical sex abuse and so on. These things just go on and on and on. And I think we could slim them down. And MPs should be banned from standing up in the House of Commons and saying we should send people to prison for twice as long, or we should have another crime declared under some new law. And there are things you can do in that sense. But clearly, it's absolutely clear that the actual process of justice is very laborious and very clumsy and very bureaucratic. And that just has to be taken we have to take a sharp knife to it. I really don't see what else you can do. You can't pretend that things aren't being done wrong and shouldn't go to court. But clearly, it's not working at the moment. And if you go anywhere near, when you go on juries, just see how much time you spend in the court doing absolutely nothing. It'd be quite extraordinary. Although I have to say, one real disadvantage with juries, a huge amount of jury trials is taken up with the judge trying to explain to the jury what the law is. This is a complete waste of time. And most of my jurors certainly hadn't a clue what they were being told. And one dear lady, I had all sympathy with her. She was from Nigeria. I don't know why she was there. She turned up wonderfully arrayed in a magnificent costume and thought she was going to court and was wondering when the Queen was going to turn up. I mean, it was on that level.
Well, I certainly think there's scope for reducing the number of people we try. One thing I'd put forward, which is highly controversial, which actually, from what Simon says, you might agree with, would be a statute of limitations for crime.
Absolutely.
Now, that's a very unfashionable view. And I'm told it's contrary to every idea of human rights, but then my views on human rights are well known. But I certainly think that we need to prosecute many fewer people. One interesting thing is, of course, that the time you take to go to trial is enormous in the Crown Court, because I think the system is creaking. In the Magistrates' Court, it's actually much less bad, or so my spies tell me. But I certainly think that, oddly enough, I don't like praising David Lammy, but insofar as he's going to try to streamline the administration of the Crown Court, I think we should give him every encouragement.
I'm entirely in favour of jury trials. In the Magistrates' Court, if you're tried for going over 20 miles an hour, which I was, and I long to go to a jury and say what I thought of the law.
There have been cases where they've taken things out of jury trial simply because they couldn't trust juries to convict. Classic example, when they first introduced it, drink driving was a jury offence.
Really?
Oh, yes. That was very quickly taken out because half the jury turned out to be drivers and said they're damned if we're convicting.
That's very good. Well, very good debate. Simon Jenkins and Andrew Tettenborn, thank you for joining us.